Now we are discussing the definitions. Section 2 of the Act gives various definitions of some important terms given in the Act. These are: first of all, let's understand arbitration. In Section 2, Clause 1, Subclause A of the Act, it defines arbitration as to any arbitration which is either administered or not by permanent arbitral institution. So, arbitration is the thing which happens outside of the court, but its decision of the arbitrary body is binding on both of the party. So, and then there must be a voluntary consent from the both parties to participate in arbitration agreement. Section 2 clause 1 subclause B of the act says that for arbitration agreement section 7 of the act must be referred. So in this, when the agreement has been reached between two parties, then it is binding on those both parties. The arbitration agreement must be written according to the section 7 which is there in Arbitration and Conciliation Act 1996. Arbitral award. Let's understand arbitral award. Arbitral award, this has not been defined early in section 2 clause 1 subclause C, but mentions that it includes interim award. Means, actually we say in criminal offenses when we have a punishment they will give punishment, but in civil cases of arbitration we get award. Arbitral tribunal, it means a sole arbiter or panel of arbiters who help in arbitration. Section 2 clause 1 subclause D. So as well we know that the initial sections of an act always define the definitions. So here we have section 2 which deals about the definitions. Arbitral tribunal, which it means a sole arbiter. There will be one arbitrator if the parties agree, or else there will be a odd number of arbitrators but not the even number of arbitration to get to a decision between the parties which is binding on them. Even though when the arbiters are in even number, the court cannot struck down the decisions which is given by the arbitrator on the sole basis that the arbitrators are in even number. So the intention of decision giving must not be fraudulent, must not be immoral. International commercial arbitration section 2 subclause 1 subclause F, it means arbitration in disputes arising out of a legal relationship whether contractual or not, and where one party is a national of another country, a body corporate in another country, company under the control of any other country or government of foreign country. So when the dispute actually happens, so we are a domestic people, the domestic people won't face any problem outside the country, but here the problem comes when the national of Indian get a dispute with the national of a foreign nation, then there will be a foreign arbitration has to be there. So in this, the award which is given by the foreign one is considered as foreign award. That's it. Thank you.